Zoning appeals to order. The first item, although it's not on here, will be the roll call. Jennifer Matthews.
I'm here.
Alex Sharp, I'm here. David Connell.
Here.
Ron Macklin.
I'm here.
And Chris Berger.
Here.
And Michelle Summers is our zoning administrator. She's here as well. Okay, the second item is adoption of the agenda.
I move we adopt the agenda.
And I had one possible addition to just throw at you before you.
You can move to amend the motion.
Okay. Okay. I don't know what the procedure is. Anyway, I was just interested in revisiting the procedure that we're going through with the planning commission. Just briefly, how they had a hearing this last time and they recommended a couple of, or at least one application for us without holding a public hearing. So I just was interested in hearing your thoughts, if any.
Okay.
So maybe towards the end,
Yes, we'll put that on under new business.
under new business at the very end.
Under two, under new business.
Okay. And I guess that's it. Is there anything else?
I have
A couple of, I think, well, are we gonna talk about the rules? I mean, I don't know if that's one, well, our rules of procedure, there's been a sort of suggestion that we amend them, so
birthday.
But I mean, no, I don't think we have that on.
well, I think we ought to put it on there.
We'll put it on for next month.
What?
Well,
We can put it
it's
on.
not- It's okay. We can be very quick. Can we just put that at the end?
I
Maybe.
don't know, we're gonna put it on before this appeal, but this comes up, I guess that's what it has to be.
It would come under new business, so.
All right, whatever you want
You
to do.
come under, number 3 under new business.
Fine.
Okay. So rules
Rules of procedure.
of procedure. Is there anything else?
There is, well, there's, I maybe rather just put it on the agenda, I'd just like to say, I know you had a discussion some months back about, right about the time you started, about all these permits that have like a time for review. And can't remember whether you said there is a list or there isn't a list, but we need to do that. Not right now, but that should be on the list of things to do, because some of them, it seems like to me that, a lot of them are like 2-year things, and I think it's time to review some of them.
Another question I had is, so we're gonna look at that as well.
Okay.
What about putting this 15 Main Street at the beginning?
Why?
I don't know,
I think that's done in the middle there.
we have an attorney collecting, I'm assuming he's gonna.
I would be in favor of that in front of what the discussion on modifications or whatever. I think that's.
Yeah, so that would be, okay, we'll put it right after this,
The public hearing.
Zook, how do you say that?
Zook.
The Zook
Well,
hearing.
Mr. Brown hasn't been here for a while. Maybe
We
he
have
wants
to,
to catch up on some of the things.
Okay, so let's do it right,
Yeah,
right after the
Because it's
Zook
riveting.
application. So that'll save you from, is there,
Isn't that where it was anyway?
well, no, it was all the way at the end. It was after this discussion of rules and modifications.
No, that's what I was talking about.
Bed and breakfast tourist zones.
Oh, that, okay.
Okay, so we need like a second.
To the
The agenda
motion
is modified.
as modified.
I'll second.
As multiply modified.
Right.
Is there any further discussion? All in favor?
Aye.
Okay, the next item, is there anybody opposed? No. The minutes, which I have not had an opportunity to review.
I have.
You have.
You want to put that over till next month,
Can we put that on?
like as we usually?
Is that it?
Well, yes, we can do that, but I can go ahead and give you, Mr. Connick, the corrections and you can.
So you could correct it prior to next month?
Yeah.
Hopefully not today.
Right.
Okay.
Now give me yours.
I got it, sir.
There, just take that
You
copy.
take that one, give me yours.
Okay. Is everybody agreeable with just doing that next month?
Yes.
Yeah.
Okay.
I mean, I would say, I would make a motion to table the minutes until the next meeting.
Is there a second to that?
Second?
All right, any discussion, all in favor? Aye.
Aye.
Okay. Now, the next item is the Zook. Zook. Sorry, I have a
The part where you say,
curve.
how do you say that?
Okay,
See if they say the same thing this time.
Zook,
Maybe it's a
Zook.
trick.
Z-U-K.
Is it Dutch?
Yes, ma'am, it's Swiss German.
Or
No,
Amish.
but I'm-
But my background is Amish from Langston, Pennsylvania.
Okay.
It's washing away up there in Lancaster. I just saw
It
pictures
is.
up on the college.
Yes.
Well, we've been getting some.
Oh, really?
Yeah. Okay, what are we just were.
This was tabled, so because they had to fix their application.
There was two things they had
And
to
then they
do.
had to get the health department to approve the whatever barrier so they don't drive on their septic tank, and I understand both those things have been done.
That was correct.
And so is there any reason we need to discuss this further?
The one thing I would bring up on this, and I've been up to the site a couple times, what I see with this site is that it's in a residential neighborhood with close neighbors on both sides. To my understanding, it's been a long-term rental for some period of time. And the owner, has the owner ever utilized the property to any great extent, or has it been an investment property?
It's an investment property.
It's an investment property.
Yeah, they've never lived there.
Right, okay. And we've discussed this in our talking about the zoning ordinance and rentals and short-term rentals and long-term rentals. Looking at this property, it has been a long-term rental, which is something we need in the county. It's an affordable rental. It's got two very close neighbors. And basically what they're asking us to do is change it over to a commercial usage. The owner has bought the property as an investment, does not utilize the property other than as an investment. And quite honestly, I think it would be more beneficial to the county, because we are in desperate need of affordable housing, to keep this as a long-term rental. I think that's a better usage. In that area, the road, Sequoia, unfortunately, is not one of the best maintained streets in the county. And it's going to be difficult for tourists or whatever coming and going.
But it is a state-maintained road.
I don't believe those are state maintained.
None of them
No,
are state-maintained.
No, it's very obvious. And this is nothing, I understand what the Zooks want to do, but like I said, I'm concerned about also affordable housing in the county. And like I said, this site would be better utilized on a long-term basis. As far as the owner goes, it's rental income.
Let's see if you can find somebody who wants to live in the town of Chesterfield.
Actually, I could respond to that if you. One thing that we were talking about some ideas about how we would modify the ordinance, and I think you're referring to those. But the ordinance as it is right now does allow for this use in this zone. And we didn't have, to my knowledge, anybody opposed to something, correct? So
The neighbors were
They were notified.
notified, right?
they were notified.
Twice, because they got a notice about the planning commission, and then they got a second notice about BZA,
And
right?
I felt compelled to
No, sir.
raise any issues.
You got no letters, cards,
Nope.
telegrams, emails?
So, and I mean,
Nope.
and we're talking about renting it to a single group at a time, not different rooms to different
No,
groups.
no,
Correct.
no.
So I mean, it does in some ways, Ron, mimic a single-family dwelling in terms of the load on the traffic and so forth. That would just be my observation.
I mean, this is just my feeling on it.
Yeah.
I mean, like I said, it's an issue that we're dealing with here in the county for affordable housing, and if we start removing, the affordable housing, which is happening in other areas also, we need people here in the county that can live here. And
And that-
the Zooks live there, And it was affordable for them, and it permitted them to be in Rappahannock County, and they have left that house and moved to another house. But that's,
Okay. And so that would be an issue probably for the planning commission and or supervisors, if that isn't
That's fine.
practical.
Yeah.
I would say, never mind. Is it anything else?
I would, as I mentioned the last meeting, the planning commission was very loose in their recommendations for fire extinguishers,
This was,
smoke detectors, whatever.
but that was a more specific, I don't know if that's.
No, this is exactly the same thing we had before. You work, as I said the last time, a working fire extinguisher is a bucket of water. What that needs to be in that house is, and I've also discussed this with our new emergency services coordinator, as far as this type of thing, and he's a firefighter, I was a firefighter, we understand. My recommendation is that there be 2 5-pound 2A 10 DC fire extinguishers, one on each level, that the smoke detectors in the structure would meet the current code, which would have smoke detectors in each of the occupied bedroom spaces and in the hall.
Are you making a motion by chance?
Yes.
Okay, and is that to approve the application?
Correct.
Okay.
And also the carbon monoxide detectors. The house, to my knowledge, has no propane, so those would not be necessary. So, and also a visible reflective address.
Those what, propane detectors?
No,
or carbon dioxide?
CO2.
No, propane detector.
I mean,
That's a
CO2.
separate thing from the carbon dioxide.
That's correct. And there's no,
Monoxide.
but the house does not have propane, so there's no need for
We
it.
just skipped over that.
Propane.
So you want to have both the fire, smoke detectors and CO2?
Correct.
O2.
But no propane.
Yeah, no need for it.
CO.
And like I said, a visible reflective address identification on
That's
the
what-
property, which is not the.
It's not there right now?
No.
That will be done.
All the above?
Yes, yes.
And no other signs, right?
No.
Okay, put that in your motion.
And no other signs.
Good.
Not even just identify.
Well,
they-
basically, all they need is an address. It doesn't need,
GPS address.
it doesn't need a,
How big is what you're saying? I mean, can it be 250 square feet?
no, it's
No.
if nothing else, it's the blue signs that the
So,
fire
the
department
mailbox.
sell, although you can buy them privately and whatever, but they're reflective, and they've got the address, and it's out there on the street, so if emergency services has to come in, it's easily visible.
okay. Is that covered?
That's it?
Did you get all that?
Well, he's gonna give it to her.
Who?
This
Matt
guy
Glover.
over here. Ron,
You were gonna get it? You just
you
gave
had
it?
it all right.
Can you get over the fire extinguishers again?
Say what?
The fire extinguishers?
Oh, a 2A 10 DC, 5-pound 2A 10 DC wall hung. You don't hide them in a cupboard.
Just give him the approval thing and let him write it, and then we'll let him sign it first, and then we'll do.
Okay, so that was your motion?
It was
I'll
my
I'll
occupation.
second that.
Okay, any further discussion?
I just want to note that I assume that the applicants are amenable to that, but as we discussed, I don't think that any of these safety things, although I'm all in favor of them, I don't think there's anything in the zoning ordinance that authorizes this board to impose those kind of conditions on a zoning permit. Those are building things or fire safety things, and I don't think that as a matter of zoning and land use, those kind of, so I've already said that, and so I just want to note that, but if they're agreeable to doing it, and they're going to accept the permit with those conditions.
Yeah, and
Well, I mean, I would just question.
And I would just suggest that our planning commission representative, who wasn't here because, when we discussed all that, take that up next time at the planning commission. I mean, I think these things with the smoke detectors and all that are great. It's a great idea, it's just not in the zoning ordinance.
I agree with you completely, and the problem I see is that there isn't any entity which inspects and approves of that kind of safety situation in Rappahannock County for short-term rentals, so that we're kind of
There's a
saying.
building.
The building official, you
Pardon me?
the building official could do it, but
They certainly could.
well, I'm not talking about exactly that, I'm talking about, there's nothing now in the zoning ordinance, if you look at the section 17052, which is general conditions for all special permits, or the specific ones, which I think is 17065K or something like that, right?
66K.
66, let's see, look, I'm close. That says you can require as a condition of granting the permit, these safety type things.
It says about safety.
Well, it talks about traffic and that kind of safety and like the fire engines being able to get there, but it doesn't talk about.
They may not have to come if they've got all the smoke
Well,
detectors.
you're right, it doesn't say that.
And quite honestly, I mean, the planning commission did make a, attempt at interjecting that, but having been in the business or whatever, you have to be specific on what you're asking for. I mean, you could,
But are those what you're put in this motion, are they what is up to code, or is that something extra?
correct.
It's code.
Right, and that's why I said the smoke, and basically working smoke detectors that conform to the present code leaves open, and if the code changes to a higher level at some point in time or whatever, and we're requiring that
Whatever
they
is
be,
the current code.
then it sort of travels through, so you don't
So
make
why
a
wouldn't
specific.
that be your motion? Just that they conform to the current code, building code, and safety code, if there is such a.
That's what I was saying, for the smoke detectors now with fire extinguishers, that's part of the PA code. And if it was a hotel or a motel, those would be specifically required. But with short-term rentals, that was not in the code at this point, it should be.
So we could actually require.
So we're asking the applicants, if they're willing to do this.
I mean, I'm fine with that. I think that if we worded it so that we could even say that they meet the code for hotels and motels, I think we should do that. And that would be.
Well, that would be
That
perhaps frankly.
varies depending upon the
Just leave it the way he itemized it out. I think it's good, and I think that we need to change our code and work with our planning commission and the board of supervisors that some of this gets nailed down a little bit better, because times have
So there's
changed.
a motion, I call the question.
Okay, there was a second to that? Did you
I was
second?
a second.
Jennifer, is there any further discussion? So we're going to approve this application if this vote carries, subject to the conditions that Ryan outlined in his motion. All in favor?
Aye.
Opposed? None. Okay.
Abstain for the reasons previously stated, I don't think it's the
Okay.
first time.
Okay. Okay, so the next item on the agenda is we're going to put the 15 Main Street appeal application, and there's a couple of issues on this, but I think tonight's issue is setting a public hearing date, assuming we get to that point. There was an issue of representation, which has been to some extent. Thank you.
Stay safe.
So, at the last meeting, this question was brought up about, a couple of issues. One was whether this application was made properly, and the other one was the fact of Mr. Chapman representing himself when he's an LLC, which is not seen as an individual. I mean, it's a separate entity, which we, at least a couple of our members, felt like required an attorney, a licensed Virginia attorney to represent in this hearing. So we did get an opinion from Art Goff, and I'm sure that's been shared with you. And everybody's read that opinion?
Yes.
And it seems like that does give us the ability, even though it does indicate that there were some flaws in the application as submitted, it did give us the flexibility, if we so choose, to accept an attorney being brought in after the fact, signing off on it, and then, I'm assuming, representing him as needed.
That's correct, Mr. Chairman.
Okay, and you're Mike Brown?
Yes, if I may, Mr. Chairman?
Sure.
Michael Brown, representing 15 Main Street LLC. Thank you for allowing me to address the board for just a moment. I did get a copy of Mr. Goff's memorandum, and I think he accurately summarizes the law. I do, with respect, disagree with one of his conclusions, and I think he contradicts himself in his memorandum in this respect, which is that the appeal, the notice of appeal itself, he believed was not validly filed. He makes the point in his memorandum that the manager of a corporation or an LLC, of course, has the capacity to sign documents, including something like a notice of appeal. And that's in fact what happened in this case. The notice of appeals was signed by Mr. Chapman on behalf of 15 Main Street LLC. I think the notice itself is very clear in that respect. And it did state the grounds for the appeal, which was the disagreement with the zoning administrator's finding that the mural was in fact a sign under the zoning ordinance. That's on the face of the notice of appeal. So my contention is that you have a validly filed, timely filed notice of appeal in this case. Now, the supporting documentation that goes along with it, Mr. Goff points out, Secretary Connick pointed out, and I agree with their observations, that those go beyond what the individual, non-licensed individual acting on behalf of the LLC could validly file. But those are not requisites to the notice of appeal itself, which was signed by Mr. Chapman in his capacity as an officer of the LLC, and therefore we submit was timely filed. So in that respect, you don't, we believe you don't need to adopt a special rule or find there's an exception or that this document relation back applies in this case. Thank you.
Well, I have a question, Mr.
Yes, sir.
Is that right?
Yes.
You kind of lost me when you said that the notice of appeal could be signed by a manager. Where do you find that in the code?
Mr. Goff's memorandum makes a note of this, that the applicant itself.
Something about General District Court, I think, and he said something about the Supreme Court adopted a rule about notices of appeal filed from circuit court, but where does the BCA have authority to do that?
He reaches into the, I grant you, Secretary Connick, he reaches into the broader law in Title 16.1 of the code and the rules of the Supreme Court of Virginia, but it makes the point that an officer of the entity can certainly sign any document necessary on behalf of the entity, not going into the realm of making legal argument or filing pleadings. The notice of appeal itself is not a pleading, it's a notice. Now, I think that the supporting information that was filed at the same time as the notice of appeal went beyond.
Okay, well, all right, I got you there, but what I want to know, what about the Wellmore case? The Wellmore case, some lawyer that was licensed in Pennsylvania but not in Virginia filed a notice of appeal that said, we hereby note an appeal from the decision of the circuit court of wherever it was, Bath or whatever, and filed it in the circuit court, and the Supreme Court rejected their appeal, and that's why this amendment to Rule 15A was adopted.
And the critical distinction there between the situation that the board has before it right now is that, yes, an individual not authorized to practice law in the Commonwealth filed that on behalf of the entity. I submit to you that the Supreme Court would not have reached the same result if the entity itself had, and again, it's a slightly different situation, but if the entity itself had been filing just a document that needed to be executed in some capacity by the entity. And that's what we have here. The appellant, the applicant, is the entity, 15 Main Street LLC. Somebody with authority, clothed with authority under Title 13.1 for the LLC has to be able to sign that application. That's the manager, Mr. Chapman.
And then we have, it looks like Art is saying that we do have, or they can correct it within 90
He's
days.
saying they don't have to correct it because,
But you did correct it in a sense, right?
because
Because
he said we'd have to
I
adopt
believe
a
in a belt and
rule.
suspenders,
Wait,
Mr. Chair.
is this your signature on this thing?
Yes, it is. I signed
What
that
was the
yesterday.
purpose of doing that?
Yes, and my purpose was to be sure that if the board disagreed with
Oh, okay.
my opinion, my argument this evening, that I would get 2 bites at the apple.
What's the
Okay.
second bite?
This is the second bite right here. See that lower signature?
Right, oh, I see what you're talking about. I have one other question for you, Mr. Brown, and that is the issue that Mr. Goff didn't address in his memorandum. And that is the state code 15.223, or, sorry, I'm getting ready to make the wrong, no, 2311, I think, A, says that to file a notice of appeal, it must be filed with the zoning administrator and with the board. And in this case, it's undisputed that the filing was only made with the zoning administrator. And she's no longer, it used to be that the zoning administrator was the secretary of the board, but she's not. And your client was well aware that I'm the secretary and who's on the board, because he appeared before the board, and he also had correspondence after that hearing directing him to file things with me as secretary. And this appeal, which came within a week or 10 days of that letter, was only filed with the zoning administrator and not with any member, or not with the secretary, and not with any other member of the board. So what about that part of it?
And this does raise an interesting question, Mr. Connick, because, I don't know that we have anywhere that I can recollect any guidance on what it means to file something with the Board of Zoning Appeals. Your contention is that means it has to be filed with...
I don't have any contention, like Coach
Well,
Parker
you're
likes to say, I'm just asking you a question.
Fair enough. Your suggestion is that in order to file something with the board, it actually has to be sent or delivered to one of the physical 5 members of the
Or all
Board
of
of
them,
Zoning Appeals.
whatever, but in this case, it was easy, because nobody got it.
I can't find that anywhere. I don't know where you find the guidance that says that filing something, quote unquote, with the board means it's going to one of the 5 board members. I think it's reasonable for the applicant to follow what is on the form when he walks into the zoning office, and is entitled to believe that when he hands that document to the zoning administrator, that is the equivalent of filing it with the Board of Zoning Appeals. Now, again, that may be a subject that this board would want to consider enacting a rule regarding, so that it's clear what in the board's view it means to file something with the board. And I don't dispute, by the way, your reading of the statute. The words are there. The statute
Of course, they
says.
just had that opinion
The
came out 2
statute
weeks
says
ago
what it
that said
says.
sometimes and means or sometimes or means and.
Right, and
So
I'm
it
not,
can mean whatever you want.
right, and I'm not going to engage in that. I mean, again, that's, we can have that debate. But so that's my answer to that question. And I do think it would be helpful if the board wants to consider some of these clarifying rules in its procedures, and you have it on your agenda this evening now, so that these kinds of questions don't arise in the future. I don't believe that they have a detrimental impact on this specific notice of appeal, but we're happy to have the board consider and retroactively enact rules that would assist us if that's the
Well,
board's.
that was going to be, I mean, your position, we don't need to do it, but I mean, if we did do it, see how they could have retroactive effect.
Right.
How soon after it was filed with Michelle did you get a copy?
I don't remember, within a day or so, or maybe the next day, I guess. I mean,
So you did get it.
You got it from Michelle.
I got it from Michelle, and she sent a copy to me, and I think Mr. Curry and to Mr. Goff.
And that would have been timely, since it was filed on June 22nd, and the zoning administrator's letter was, I believe, May 25th.
But Michelle sent it, the
Yeah,
applicant.
I
didn't send it.
got that, I understand that. Okay, so I think initially we would have to rule upon or make a determination about whether this was made timely, that we can actually accept it.
And if so, then set it for hearing.
Okay. I think as I expressed in a couple of emails, I think it's better to actually hear the case rather than just throwing it out on a technicality if we can. That's my personal opinion, I think.
Well, I have, before McCarthy left and before Debbie Kaiser left, before Debbie Kaiser left, we had been trying to get some of these, our procedures in place because it was a little bit of this, a little bit of that. And in that we don't have it in black and white. I don't think we can fault someone who says this is the zoning office, I come in here and this is the documents I present. Some of the burden of errors is on this board's part as well as some of the other boards in the.
And we did get an opinion, and the opinion does give us that leeway. Now, we're not required, I don't feel like we're obligated to hear this either, but I feel like we should, or I'd like to see us hear it.
I was going to say, I think that obviously it was not a perfect appeal, or the whole process, there were some mistakes that were made. I don't think there was any willful attempt to get around any ordinances or codes or whatever. And quite honestly, from what I've heard or whatever, the community would like us to handle this situation in a positive fashion. And so I think we should go ahead and
When you
set the appeal for a hearing.
When you say positive, you mean just not the outcome necessarily, but the process.
There appears to be a tremendous amount of support in Rappahannock for this particular mural, sign, whatever you want to call it. And I think it puts us in a tough position because we are sort of having to skirt things a little bit or whatever in order to make it work. But I think in the end, I don't think anybody's going to call us on it or anything, and I don't think it's necessarily, it may be precedent setting. But at the same time,
Procedurally or as for the sign?
What?
It'd be precedent setting as to the definition or precedent setting as to the procedure? Or both?
It could be both, I don't know. As I said, this is tough. And we got to figure this thing out, but it's and the other factor that hasn't really been mentioned that much is the fact that the sign ordinance doesn't have a great history in that.
Wait, point of order.
Okay.
Way behind.
I
agree.
I think what we're actually deciding right now, and at least how I think we're deciding, is whether to hear it. And if so, we're going to set a date.
Okay.
And so, I don't think this obligates us to approve it or deny it or anything.
No, it doesn't.
So we'll hear
We
that.
haven't even
Yes,
heard the evidence
absolutely.
yet, so
Right.
that would be a little
Absolutely.
premature, wouldn't it?
But
Yeah.
what I'm trying to say is that the community wants us to do something about this. Take action.
Okay. Good. Chris, you have any thoughts?
No, I agree with you.
I think that, as I said, some of the error and onus is on us for not having this clear set of procedures. We have worked, she has put together a number of sets of procedures. We just haven't gotten all the way through them. So if he handed the paper to the wrong person, but within 36 hours, everybody had a copy of it that needed to have a copy of it, I have no problem
So,
with that.
now what about, well, I guess we should first make the determination whether the application was properly submitted.
Right.
Is there a motion to that effect?
I would make a motion that the application was properly put forward as amended in that now, because of Artkoff's letter, it has been signed off.
Okay, so you would
And
make
Mr. Brown's signature to it.
we would make a determination that the application was properly submitted based on
That the
as-
application that we are acting on has been
No,
properly,
yes, as we
has
have
been
it
properly
The
submitted.
amended one that we can act upon.
Okay, is there a second to that?
Yes.
Chris is second. Is there any further discussion?
Yep. I'm gonna, I mean, I don't support the motion, and the reason is that I think the rules are clear. And I respectfully disagree with Mr. Makala that what the community wants or doesn't want, this is not a popularity board. This is a board that has to apply the zoning ordinance and the state code as it's written. And it shouldn't be swayed by whether there's nobody here or whether the courtroom is packed and people are down the stairs, you know, campaigning for one or another interpretation of anything, because you're just inviting a real mess if you do that. I think we ought to stick to the law. Number two, I don't think the appeal was properly filed because, despite what Mr. Brown said, I don't agree that a notice of appeal of a zoning matter is something that can be filed by anyone on behalf of the entity other than a duly licensed attorney. And the case law says that, and the statute says that. And as a matter of fact, it's a criminal misdemeanor for a non-licensed person, or a person who is not licensed to practice law in this Commonwealth, to file a pleading. And that's what happened in this case. A notice of appeal is a pleading. And the fact that it states, however, in whatever abbreviated form, on the form, and now we're going to start playing it like, well, we're not going to count the multi-page attachment to the form, which states the grounds for appeal, as the statute requires. We're just going to focus on one line in the application form, but that's a, can you put that up on the?
Are you talking about this right here?
I'm talking about that right there, that says, I mean, that's what Mr. Brown argued, and that's what Mr. Goff sort of said. How is the appellant an aggrieved person? Well, that's not the grounds of appeal. But anyways, it says zoning administrator wrongfully defining mural as a sign. Well, that's a legal argument. That's a legal conclusion based on an interpretation of what the ordinance says. And yes, it's very abbreviated, but it's a legal argument. It's not a fact. That's the issue in the case. It's not a fact, and that's the only thing that a non-lawyer can testify to or file is things that are facts. And whether or not the zoning administrator wrongly defined mural as a sign is the issue before this board. It's the legal issue before this board that the board has now made, that there's a motion pending to approve and to hear it. And that's the legal issue. That's not a factual issue. So, therefore, the notice of appeal that's required by law containing a legal conclusion was filed by a person that's not authorized to file it, and that's not only improper and makes the filing a nullity under Virginia law, it's also a criminal offense. And I don't think the board should sanction or encourage that to be done. And I appreciate the arguments. Well, it's a technicality, and I appreciate the arguments that have been made, but I didn't advise the applicant or the principals of the applicant to form themselves into a legal entity. And when they took that step of forming a legal entity, there's certain stuff that comes with it. There's certain requirements that come with it. It's not an individual, it's now a legal entity. And as such, before a tribunal like this board and the Virginia State Bar Unauthorized Practice people have written a letter and said, yes, the board is a tribunal, And their opinion was that the notice is a pleading. And this case that was cited, this Wellmore case, that didn't even have any grounds of appeal. It just said, we're going to appeal it, period. And it was signed by a non-lawyer on behalf of a corporation, and the Supreme Court rejected it. Now, subsequently, they thought just what you all are thinking. That was a really harsh result, as a consequence of which they put in this amendment that gives a court the discretion. It's not automatic. It gives the court discretion to overlook this default if they correct it within 90 days. And so that's another reason that I oppose this motion, because we're not even going there. We're going to overlook the whole thing. I mean, I might be okay with passing or adopting a rule that says if this happens, and I might even go so far as to make that retroactive to apply to this case. But to just say, well, what happened here was not a violation, and what happened and what was filed was in accordance with it, that's not what Mr. Goff's conclusion is. Mr. Goff went through it point by point, and at the end he said, therefore, this filing violated the rule on unauthorized practice of law, and it is not a valid notice of appeal, and therefore it should be rejected. However, then he went on to talk about the amendment after the Wellmore case was decided to rule, I think it's 1:5A, that allows, or E, whatever it is, I forget what subsection, but it's C or E, I think, of Rule 1.5, that you can correct it. Well, my question right away is, okay, they said in circuit court you can have that procedure, and it's up to the discretion of the court, not automatic. How does that apply? How do you jump from circuit court to the Board of Zoning Appeals? And that question remains to me unanswered. And I have said many times, the Board of Zoning Appeals is a body of limited jurisdiction and authority by law. And I don't see anything in the law that allows us to overlook the criminal laws of this Commonwealth and say, okay, somebody filed something here that's not only not in accordance with the rules, but it's a criminal violation. Well, he's a nice guy and the community wants us to do it, so. Well, you sort of are saying that, and so that's what I heard.
Well,
let me finish. I'm just about done. So I don't agree with that. If we passed a rule that said that if the applicant showed a good cause why there was a non-compliance or an oversight or something, and then we haven't heard anything. We haven't heard any excuses. We haven't heard any alibis. We haven't heard any explanation of why this happened. And I just think that's improper, and it just encourages people to violate the zoning ordinance or disregard what it says. And yes, I'm sorry, it's legal stuff. You've got to jump through all the flaming hoops or you're out. And Mr. Brown knows that, and I know it, because if you miss a filing deadline and go crying to the judge or the Supreme Court or whoever it might be and say, my dog ate it or my car broke or all my horrible experience, that why I didn't get it done, it's too bad. Okay. There's a deadline. You've got to meet it. You've got to make a proper filing. Mr. Goff's opinion is it wasn't a proper filing that was timely made, and we don't have any rule, although I'm willing to adopt one, if the board wants to do that, to let Mr. Brown, come in late and correct it.
Let's go ahead.
All right.
Why don't we put that motion just to set it aside for just a minute? Why don't we make this amendment to our rules of procedure that allows, upon notice to the applicant, that would allow them to remedy this type of deficiency within 90 days?
I would be unwilling to do that without studying the issue and getting legal advice as to the wording and everything.
I agree with that. I mean, I don't think we can do that tonight. I would move that we do
agree with that. And I feel that what we are dealing with right now is a failing of the county and the board to delineate the proper process for making an appeal. And that it is unreasonable to expect a member of the public who in good faith goes to the zoning administrator with a zoning question to understand all of the ramifications of that, and that I think that it is impingent on the county and the board itself to delineate what the problems are and how they need to be addressed before the appeal is made, not after.
Okay, so why don't we just go ahead and vote on that motion then?
Well, I mean, I'm looking at what Mr. Goff says, is I do not think that this statement, the handwriting on the line that says, zoning administrator, elevates the notice of appeal to the status of a pleading. He said that about twice in here as he's gone along, and then he defines that pleadings are formal allegations and, you know, law and provides notice and so forth. And so,
So that would mean we should go ahead and vote on this.
and then it says the BZA must, however, take, and the BZA is empowered to make such a decision as a preliminary matter and summarily dismiss an appeal based upon perceived deficiency in the notice. He's asking that question, so that must be open, that we do have a bit of wiggle room. And I don't know Mr. Chapman, but I don't know that he was going around calling himself a lawyer. There were people going around calling themselves physicians or nurses or, you know, something like that. So I don't know that he was doing that. I think he was doing what he felt was part of his, like, you know, rights as a citizen to walk into the office and say, you know, this is
Well,
it.
it seems to me to find him a criminal is tantamount to entrapment. You give him a form, he signs the form, bam, got it. And this is a...
But that's not what happened.
No, it's fine.
exactly
Let's
what
not go down that. How about if, and what about these other arguments? Can we give Mr. Brown leeway to submit a pleading that states more fully the case?
Well, that's already been done. Haven't you endorsed the thing that
He
was
endorsed
attached?
this. Oh, you endorsed the attachment as well?
I signed the notice of appeal, or the
But
what's
you
called the
didn't
appeals
endorse the
application.
attachment. Why don't we give him,
Well, what about the other part?
why don't we give
You didn't sign off on that?
I haven't, I did not put my signature on it.
rather than having a non-lawyer's thing being submitted, why don't we give him, what, a week to submit the case?
Well, Mr. Chairman, it seems to me it depends on what the board's going to do as far as whether they believe the application is timely.
We have a motion here, and so if we approve that, we're saying we're gonna hear it.
Now,
But then we don't
the next
have
matter,
much.
the next matter you'll need to take up then is the scheduling of the,
But we don't have much. Is this all your argument's gonna be limited to?
no, Mr. Chairman, it's not.
Well,
Don't you,
but it would be limited to that if there's no other filing.
don't you need to get something in?
That's correct, but it depends, in terms of the timeliness of it, it depends on what the board's going to do in terms of scheduling a public hearing. And that's going to be, I assume, it's going to be a topic of discussion once there's a preliminary.
Right after this passes 4-1.
We can,
Is there
that's my
a stipulation on the form that the additional information has to be filed at the time that the form is filed?
No, it's in the-
Doesn't say one way or the other.
That's where what Mr. Byrd said is just flatly wrong, because the zoning ordinance says, if you want to appeal a determination of zoning administrator, did you bring your code again tonight? It's right here. It's in I think 140 or 145. It says, you have to file an appeal within 30 days, and the procedure, it just incorporates by reference the state code. That's all it says. You have to do it within 30 days as prescribed by 15.2-2311. And that, by the way, was just amended in 2015.
but he has they have 90 days to.
No,
correct.
we have 90 days. We don't have any such rule. That's what the Supreme Court adopted as their rule.
And that's what Art Goff
Well,
said.
Art Goff said we could do something similar, but I have to say that the zoning ordinance also says if we don't act within 90 days to reverse or modify the zoning administrator's determination within 90 days from the date it was filed, then it stands. It can't be reversed after 90 days. Now, So a 90-day rule is not gonna work here in the Board of Zoning
Okay,
Appeals.
let's say we're not gonna let it go that long. Can you, within a week, write up a summation of the argument and get it to our?
Well, the grounds of appeal, but
The
that's
grounds of
supposed to be
appeal.
filed within 30 days, and I think
Well,
that's also, wait a minute, Mr. Chairman, now, you're saying, okay, first, what Art Goff proposed was, well, if the attorney countersigns what was already filed, that cures it. But now you're giving him an open door, some two months
I'm
later.
not giving him anything.
Well, you're suggesting that he can now throw the door open and start writing new additional grounds of appeal that, 60 or now it's 70 days. If you add on another week or something, it's 70 days after the decision was made. And that's clearly unauthorized by any law or even the Supreme Court rule. You can't do that. You can't just make up rules as you go along.
Are you talking to me or to him?
I'm talking to all of you.
Okay.
But especially the board, I think that's
Okay.
just, that's inviting disaster. And because the ramifications of what we do here has nothing to do with this sign or nothing to do with the mural. And I think Mr. Brown understands that, and I hope Mr. Chapman understands it. The issue that's before us has a much broader impact. And what you said, I'm very sorry, it says in there, you have to file within 30 days a notice of appeal specifying the grounds. Now, I don't see what could be more clear than that. You have to say what.
And when Mr. Chapman went to the zoning administrator and filed his appeal,
Right.
he was not doing that?
No, well, what he filed, it's all the grounds of his appeal are in the other piece of paper, which, by the way, if you read it, I don't know if you did, apparently you didn't, he cites and quotes at great length from that very section, 15.2-2311, and says this is the basis of why I'm appealing and so forth and so on. And so he obviously had read that section, and if he had a question about it during the 30-day period, he could have called Michelle and asked her, or he could have called me as the secretary, he could have called Alex. He certainly had appeared already before the board on his variance application, so it wasn't like he didn't know who to call or ask if he had a question. And I would have been glad to explain it, or to the extent I could, but my explanation pretty much would have been, go get counsel.
But his intent was to conform to the law.
How do you know what his intent was?
Because I believe that was his intent, and that he was not trying to skirt the law or whatever. He was attempting to do what he thought was right.
He was? How do
Obviously,
you jump to that conclusion?
Okay,
Mr.
now,
Mackey?
hold on. Let's go ahead and vote on this motion, because we might as well.
Can you repeat the motion, please?
We were going to make the determination that
It was properly filed.
that the application as amended with the addition of Mr. Brown's signature is properly submitted.
Thank you.
Or, Scott, I think we should say,
Accept.
based on that, we are willing to bring it forward to a
Accepting
public
that
hearing.
as submitted so that we will go ahead and schedule a hearing.
I mean, yes, we are sort of making a determination here, but that's
Well, that's what
we've
we're
got to
doing.
move forward.
That's what we're doing. Okay, all in favor?
I'm in favor of that.
Aye.
No.
Okay, so 4 to 1.
So now we have to decide when we're going to hear it.
Okay.
Mr. Chairman, may I address the board for just a moment?
Sure.
Thank you, I appreciate that. I'm happy to adopt, and this evening, if it suits the board, the additional pages that were attached to the initial notice of appeal, and stand on that argument. I think it's well reasoned, and if I have anything to add, I'll be glad just to argue that at the public
Are
hearing.
we going to accept additional arguments?
Well,
When I'm thinking back to some of the other appeals we have with Harmony Manor and so forth, we, almost
Wasn't an
every
appeal.
week, we got more and more emails from,
that wasn't an appeal.
well, it almost
There
was,
was.
it came to the
Circuit
same.
Court?
No, there was an appeal to, what was the ruling about
And-
whether
That
it was
came to
the
this
2
board.
extra bedrooms,
But-
remember?
but-
That was an additional special use permit.
What
application.
No,
That wasn't an
was the
appeal.
appeal was the zoning
They
administrative
withdrew.
ruling
They withdrew.
that they hadn't
But up to the day
fulfilled
of
the
the
requirements of
hearing.
the-
But then they withdrew it, so we never
So
heard
we
it.
never
That's
heard
true,
of that.
but as we moved up to the day of, or the day before the hearing that we were to have, we were receiving documents weekly from the attorneys of.
I don't recall that.
Yeah, so that's,
Oh,
no,
I've got it here.
that's true. Hey, you don't
From the
have,
attorneys? I don't think so.
you don't
The,
have.
the
Anyway,
attorney, the
whatever.
attorney out of Manassas.
Okay, we don't have to prove that. Okay, now, are we going to accept a updated attachment?
Well, no, he's gonna endorse.
I'm happy to endorse and adopt the.
Okay, are we
Okay,
going
fine.
to accept any additional arguments that he might make?
Is
That would
that
be a
what a
public
hearing
hearing.
is about?
I think that would be a determination of public hearing.
We're not gonna.
But, I mean,
determine
I
that.
would
That's what
like-
they are.
I mean, I'm thinking if you just go ahead and submit something to us, if you have any additions, because obviously this is going to come up at a public hearing as to whether we're going to accept anything outside of the limited scope of what's been submitted.
Well,
with the
Mr. Chairman, I
application.
just think that's totally improper, but that's the reason the statute says what it says, so that we get a list of the grounds of appeal, 1, 2, 3, 4, 5, however many there are. I mean, I just filed one down in Louisa County, and I had, you know, and I'll tell you what happened. And Mr. Brown, I'm sure will find it instructive. I wrote a notice of appeal that had 9 grounds of appeal in it, and filed it down there with their Board of Zoning Appeals, and I got a letter, the ninth appeal issue was what's called in law the Mother Hubbard Clause, like anything else I think of between now and the hearing. And I got a very nice letter from the county attorney telling me, "Dear Mr. Connick, the statute requires you to lay out your specific grounds of appeal, and so your Mother Hubbard Clause, number 9, will not be considered at the hearing because you didn't specify it within 30 days. You can't make up stuff after the 30 days. And that's the whole point, to give the board notice of what, and the county attorney and the zoning administrator, she's a party. I don't know if Mr. Goff's going to represent her and appear, but he's entitled to know what the grounds of the appeal are. And that's also the rule in the Supreme Court. When you note your exceptions, you got to give them a list of an assignments of error. And so it's the same procedure. And if you start making up new stuff, as we sometimes try to do as we're writing our brief and say, oh, look at this case that I didn't see before, you can't, it's too bad. If you didn't put it in your assignments of error, you're out. And that's the same rule here. It says you file the notice, it's notice to us, it's notice to the zoning administrator who's a party, and her counsel, the county attorney, if he's going to be a participant, so they know what's coming and they can prepare for it. And to now say, well, now the barn door's back open,
No, it's-
just, wait a minute, just because he didn't comply with the statute he should have complied with to begin with by getting an attorney to file it for him, that's going way beyond.
Okay, could I,
The pale.
is there a motion perhaps to give Mr. Brown maybe 10 days to submit a revised?
I think Mr. Brown has said that he's willing to sign off on what was submitted,
is it-
and I think we should accept that.
Nothing additional?
I'm happy to argue the appeal on the basis of what the board already has before it. It's fine.
And you're not going to bring any new issues into
Oh,
it?
I reserve the right to make all the arguments based upon
I did that.
based upon the grounds of appeal that have already been noted in the written material.
Shouldn't, I mean, is that acceptable to you?
It's very acceptable.
Really? Okay. Okay. Well, let's talk about when we're going to hear it. And did I understand?
We have a scheduling problem, yeah, Mr. Chairman, that the
No, I'm-
zoning administrator, right, she
She
can't
might-
be here on our regular meeting, so we could change the meeting.
So we
But
can.
we'd have to do that now, because we'd have to put out Freedom of Information Act notices, because we already adopted a schedule. So if we're gonna change that schedule, which we certainly can do, we're gonna have to get out the note, we're gonna set another date, and
So is your availability?
Well, there's also a question, Mr. Chairman, about the fact that, as I understand it, there's a zoning text amendment that is it's somewhere in the works to address this question of murals and signs. So it may be that it would.
So we don't have to hear it then?
Well, it may be that the board
Well,
will.
wait a minute, we have 90 days, and so it was filed May,
June 22nd.
no,
June.
right, June 22nd. So we got July 22nd already passed, August 22nd, September 22nd is the 90 days.
Okay, hold on. We
One might argue that it was only filed yesterday, Mr. Conklin, and I endorsed it.
No.
It says in the rule that Mr. Goff cited that it
Okay.
relates back to the original date, so we count from there. So we have to hear this and decide it by September 22.
Unless the applicant consents to a continuance beyond that date.
Well, I haven't heard that, so.
Well, we have to sort of look at our calendars and see.
Well, and that's, okay, Mr. Chairman, and that's what I'm suggesting, is that the applicant would not object if there's a sense on the part of the board members that it would be appropriate to set the hearing date, the public hearing date out on this, to see if there's some zoning text amendment that comes along from the planning commission and the board of supervisors.
So you want to revisit this next month?
No.
Well, I would.
Because, wait a minute, that's what I was gonna say, before we got into that. First of all, to my knowledge, there's no text amendment that I've ever seen, and I kind of pay attention to that stuff. So it's not at the planning commission. The planning commission hasn't even looked at it, much less set a public hearing, nor have the board of supervisors done anything to send some proposal to the planning commission. And so, once that got in motion, the planning commission, I'm gonna just assume that they would at least talk about it at least one meeting before they set it for a public hearing, but you never know. You know, they might be swayed by how fast everybody wants this to get resolved. And so that's gonna be at least 2 months, so it's not even written to my knowledge, so that's August. September, they could set it for public hearing in October and send it to the supervisors in November. So honestly, I don't think
who
that
is hurt by deferring the hearing?
Because we're
It
going
would
to have
seem
to
to
do
me
it different.
only the applicant. And in this case, if the applicant does not.
I don't agree with that at all either. Because the zoning ordinance is there. It's the law. I mean, it's like getting a speeding ticket and saying, hey, you know, Judge, they're talking about raising the speed limit on this road to the exact speed that I was going and when I got stopped. So why don't we continue this case and let's see if they're really going to raise it. And if they raise it, then I won't be in violation, even though when I was speeding, come on, you know that wouldn't work. And that's what you're proposing.
Okay, let's set it for the 29th of August. How about that? To be heard.
To be heard?
Yes.
So that's the 5th.
5th Wednesday. That happens to be 5 Wednesdays in August.
That suits you? Do you know if Mr. Goff is going to represent you in this? I mean, he didn't represent you in the last appeal we had. Have you talked to him about it?
I have not.
Do you know Mr. Kerr?
I don't know the answer.
Okay, well, I guess we sort of need, well, I guess we said it and it's not good for Mr. Goff.
I mean,
Don't
but you
you
can
say?
be here on the 29th?
Yes, sir.
And can everybody else be here to your
Do-
knowledge?
Yeah.
Do we want to go a little earlier in the day?
No. Do we
I
not?
don't care. Really. I think 7 o'clock is.
What day of the week is that?
That's
Another
a-
Wednesday?
It's a Wednesday,
5th
like
Wednesday.
3 o'clock or something like that.
I don't know if the courtroom is available, and if it usually
Since
is.
it's a fifth.
Well,
That's also quite honestly inconvenient if it's a public hearing or whatever.
Okay.
that,
But we-
uh,
because
Now,
we
is
have-
this a
we have
public
moved
hearing?
things up.
Because we've also determined that it's a matter of we're gathering evidence and it's not just everybody speaks about it.
It was my understanding.
You have to have a public hearing.
That it's a public
But
hearing.
that doesn't mean that the public is necessarily speaking.
Yes, they can listen.
Well, we've
They
had
don't-
that debate, and by the
We
way,
have had
on
that.
that happy topic, before you go into your motion, you know, based on the very same Harmony, Hollow, or
Manor.
Manor, good. That one, about 2 years ago, we agreed amongst ourselves, as a part of the resolution of all that stuff that happened in the wake of that case, that Mr. Goff would ask for an Attorney General's opinion on that very question of whether the public can speak or not. And he submitted it in November
We've
of
never-
last
we've
year.
never gotten it.
And we have never gotten it, so I would like to, well, I'm gonna make a motion, but let's do this first, that we ask also Mr. Goff, or ask the chairman, they asked Mr. Goff to remind the Attorney General's office, who told us they usually take 2 or 3 months, so that would have run out in about February. And remember, we had an appeal that was then withdrawn. I can't remember what it was.
And that was the Harmony Manor.
Well, Harmony
one
Manor
was
got
withdrawn.
repealed.
Another one
There
this
was
past
another one.
February, and I wrote down there.
Huh?
Anyway,
Yeah, okay, so let's say
August 29th.
at 7 o'clock. Is there a motion to set this hearing for August 29th at 7 o'clock at this
So
location?
No motion.
He motioned.
So
Did you
moved.
second it?
I second it.
Okay, and all in favor?
Aye.
Aye.
I'm going to abstain because of my prior vote.
Okay.
But I will get out the notices in a timely way. And I'll
I mean, I
also
think
have to
that's-
put out a Freedom of Information Act notice of the change of the meeting date, so I'll do that
Well,
promptly.
will we meet on the,
No,
so,
we're going to change our regular meeting
so we will
date.
not meet the week before?
Right,
Okay.
that's my understanding.
Is
I
that-
think we have to do it that way, so I don't think the Board of Zoning Appeals can have special meetings. It's not in the
Okay.
code.
We're gonna change that too.
Okay, so it's a regular.
Well, not our code, the state code. So,
Okay.
all right, at 7 o'clock. Now, I make a motion that we ask our chairman, Mr. Sharp, to inquire of Mr. Goff to
About the
remind the
attorney.
Attorney General, because we need, again, we need to know when we have our hearing, are we supposed to let the public comment or not? And,
No,
Now, has he rendered us an opinion on that?
no,
no,
he did not. He was supposed to get it from the
Okay.
Attorney General.
Would it be acceptable if he renders
No.
something?
I want the Attorney General.
What if that's not happening?
Well, we've passed our 2 or 3 months several times, so maybe it's just in someone's outbox.
or it not.
Okay, well,
Maybe it's buried.
I will definitely make that inquiry. and-
Okay, all right, so that's my motion. Is there a second?
I'm sorry.
Yes, Mr. Chair.
Well, you were busy.
All in favor, aye.
Aye.
Okay.
Thank you all.
Okay, and that question is to whether the public has
The
the.
right to-
Previous question.
I have to say that based on my experience in Louisa, having to sit there for an extra 45 minutes or an hour
So the public did.
listening to people talk about things that were largely
I mean, I don't-
irrelevant to the legal issues.
I don't have an objection to the public speaking, but
I do.
you do. Okay. So we will determine.
I mean, if it's relevant, and I think that's up to you, Mr. Chairman, I think that you need to tell people that the issue before the board is, or the issues are this, and this. So don't get up and start telling us about what they do in Timbuktu, or when I lived in some other place, they allowed it, because that's not the issue. The issue,
The issue is between the board,
right.
it's between the appellant and the zoning administrator. And,
Okay,
and that's it.
It's
And-
specific to a specific sign. so you
Right,
can't
and no
be
one needs to talk about it. When you have
all this stuff
Perry
all over
Mason
the
and all
place.
those, they don't, people in the audience don't speak. It's just,
Okay, well, we can make that determination.
Well, you're gonna be the chair, so you're
I'm-
gonna have to rein it in, I suppose.
I'm open either way.
And plus, if
We need to
they,
get a gavel.
don't,
No, we can take a vote on it.
if what's passed is prologue, I mean, when the variance thing came up, there was an awful lot of people here that, to my surprise, were all here for that and not to hear the reading of my minutes, I recall, but,
Well, did we want to follow the agenda?
I'm just saying, you're gonna need to,
Okay.
I think we gotta set a time limit of some
And
kind.
what is it? Oh, okay. And this is gonna be in this room, right?
Yep.
Okay. There you go, Mr. Connor. Okay, so the next item, and I don't know how much we want to get into this right now, but the Planning Commission had a meeting, a work session, where they discussed these various May amendments. And apparently, I'm assuming everybody knows what the May amendments are. Oops. Do you?
go ahead and review it.
What do you mean review it?
We just,
Oh, so May of 2015? Was that 16?
oh, so that's
Whenever it
these.
was, a couple of years ago, there was a bunch of amendments proposed to the ordinance. I think Mr. Connick was responsible for writing up a lot
Right,
of them.
that's what these are.
If not all of them.
Great.
And there's a spreadsheet, and they've been they've been discussed a couple times. I don't know if they were even advertised at one.
No, they were all agreed
Okay.
to, and as they're on the spreadsheet, and then various people got appointed to the planning commission, and others left, and the zoning administrator left, and we got a new county attorney, so they never got set for public hearing, and now everybody who's on there now, and so forth and so on, all wanted their bite of the
Okay,
apple,
so this is on board docs. I'm assuming people can go to it and find them. Anyway, we had a meeting, continuation of our last month's meeting. We met at the visitor center downstairs and just had a little work session, continuation on some of the amendments that, or the issues related especially to tourist homes, bed and breakfasts, boarding houses, what else is there?
B&B.
And, yeah, Airbnb type of thing, has been discussed. And so we discussed at some length. I think our main conclusion seemed to be whether certain categories of it really needed a public hearing before the Board of Zoning Appeals, or whether certain types of them could be handled administratively by the zoning administrator if they met certain criteria, such as primary residence of the property owner, not rented out for more than a certain number of days per year. Am I missing anything? I mean, so basically, and then that's the basic. Then there was discussion, are there boarding houses? We don't know of any. Maybe that's something that doesn't need to be in the ordinance. There was some discussion about owner-operated versus manager-operated bed and breakfast, I think.
Or not
Versus
operated
no
by
one there at
anybody
all.
Or nobody, okay, not operated at
It's
all.
also it's unsupervised, which is
Supervised versus unsupervised. So we came up with a number of different what-ifs. And I think the main one that seemed to be new ground was this idea of what would require a permit issued by the Board of Zoning Appeals versus one that could be done administratively. And that seemed to have some traction. But anyway, so I attended, Mr. Bird was not going to be at the work session at the Planning Commission yet, so I attended that and spoke somewhat, although I will say that they seem to be looking for some level of input, but they do not want us drafting. At least that's what I got. They don't want us submitting code draft wording for whatever reason. And I think they basically, if I talked to Gary Light, I think what I recall him saying was he didn't think it was helpful to have 2 or 3 different groups kind of in parallel producing wording. Well, I don't know.
It's better to have just one that's not doing anything.
Okay. Well, anyway, I think the idea from talking to Gary, he seems to feel that Michelle, you're tasked with drafting.
But if you've got a whole lot of ideas, then you can start melding them and integrating them. And one of the other things that you did not mention was that we were wondering if there could be a permitting process where that every other year, they need, when they come in to the Commission on the Revenue, say, okay, this is what I have, and then that would be at that time that they would write an attestation saying that I've got the CO detector and so on.
And that was one thing I just want to say that I neglected to say. I think we also discussed whether it would make sense to have some of these things permitted for a finite period of time.
Right.
So that it wasn't, as a lot of these are now, there's the assumption if you get a permit, even if you discontinue, you have it forever.
Yep, so but
And
renew that every
One of the
year.
issues that prompted that was Art Goff apparently in reviewing what's in the May amendments. One of the things that was put in was what I guess we would call a sunset clause, that if you like with a non-conforming use, if you stop using your special use permit for a given period of time, 2 years, 1 year, whatever, it terminates. And Art Goff's opinion was that might run afoul of problems about vested rights, that once you're granted a permit, you can't take it away unless you violate it. So if we don't put conditions or time limits on it, when we grant it, you can't do it after the fact, is pretty much what he's saying, even if they stop using it.
Well, but that's a different amendment. That's one that relates to when something
Right.
terminates.
Well, right,
And
so
I
if we don't put the, we generally don't put it like this one we just gave it, it goes on forever, and the Zooks or whoever, the people that they really are the owners, if they sell it, that permit goes right along with it, because you
So
didn't
that-
condition it on that owner, and I think we have to start doing that, on a more regular basis and put time limits. And by the way, when you read, I think it's a horrible mistake, and I think it is a mistake in the zoning ordinance. I don't think that's what it was supposed to say, but if you read the last clause of the sign ordinance, you will see that if this board or the Board of Supervisors in granting a special use permit doesn't put a limit on the sign square footage, they automatically get the maximum sign square footage that's allowed in commercial. So if you approve any kind of a thing it's like some of these home occupations that we've approved, and we don't put a specific limitation on the signage, the default is
Big.
big.
Oh, wait, isn't that in a commercial zone?
No, you read it,
In a
read what,
commercial zone.
any zone. You get the commercial zone signage, even if you're in an ag
For
zone.
what use?
Any use.
Well, that
You could
means-
have one of those home occupations, or like, who was it up here, that had the kitchen, and she didn't have any sign, she didn't want to put up any sign. And so we didn't put any restrictions on the signs, but it says in there, unless the board, when it grants the permit, restricts the sign to some amount, to some
We
square
didn't
footage.
restrict their sign.
I know we didn't. Well, yes we did, because I suggested it for that very reason, and he said, only
No,
that
we
sign,
just require-
only that sign.
okay.
And so if you don't do that, they can have, I guess the biggest is 150 feet. If they have to get a special
But
use
some
permit.
some of it in here says if you don't start erecting the sign within 6 months of when you're permitted, then it goes void. I just read
Well,
that.
that's if you don't, but if you do start doing it, and some of these things, they don't have to erect anything, it's already there.
Okay.
It's already,
Because
so-
signage starts
I
on
think-
170.93.
Okay, well, obviously, there's issues to look at
92.
with signs as well.
I was gonna say, as far as working on the sign ordinance, on the short-term rentals or whatever, it affects 3 different groups. And it makes no sense to me that one group is sort of the group that's putting it together, whatever, and that it's gonna have, in order for it to get to fruition as code or whatever, it's gonna have to go from the planning commission to the board of supervisors to be passed. And so why not put together some sort of a committee
Oh, my
or
God.
study group
What
that has BZ people on it, planning commission, and board of supervisors, so there's a general agreement when the thing is done that this is what's gonna go through, and
And the planning commission would have to agree to that.
that they would start out there, but the initial document would be put together by the 3 different groups.
You're not
because
the
we
first
have-
to have
we
thought
have-
that thought.
We have issues that we have to deal with
That's right.
that the planning commission doesn't have to deal with, so, but we need to ensure that that's dealt with in the code.
Which is one of the
well,
reasons
that's
we
why
have.
That's
we've got
why
a
we-
representative,
that's
and that's his
why-
job to bring it up.
Yeah,
And
that's
we have
why.
been trying so hard to bring this up that maybe if we have work sessions.
Well, we can also bring it to the board of supervisors as well. I mean,
Well,
it
I
would be
think
nice if
it would be quite reasonable as a result of a work session to have a draft voted on by the BZA to take to the planning commission with the concerns that the BZA has.
and I
about-
just did these verbally at this meeting, but we could,
No,
We've
that-
been writing.
But they don't have to, you know, they can take it up, or it's just like
I
here.
was gonna say, what happens
I mean,
also in
what
those
is the
situations is you gotta,
difference? The May amendments were mostly written by you,
Yeah,
who was not on the planning commission,
right.
and they took them and used them and were quite happy with it, it seemed, or at least using it as a,
Right.
something to work from.
Well, that's
And
all it
so-
was intended to be.
Of course, and that there's no reason that we as a board here, particularly knowing our problems and our limitations with the existing zoning ordinance, can't give recommendations.
no, that's what.
And I think
I'd
that
say
that ought to
yes,
be the
yes.
result of our work session.
Yes,
right, but it also becomes sort of a negotiating process when you have a group made up of 3 different groups, and that something comes up, and you go, well, okay, that's fine, but let's tweak it a little bit, rather than going back and forth and back and forth, what we've been doing, and nothing happens, because it's just going back and forth and back and forth. Try to put a group together that can come up with a document that doesn't have to go over here, you know, that when it goes over to the other groups, that you're pretty sure that you're at the approval point. It's not gonna be picked to death and then have to go back and look at it again, and then go back and forth. And we can get this, how long have we been working on it forever, and nothing's happened?
Well, the answer to your questions, and I mean, that's
It's
just my
birthday
view,
day. It's a birthday
is
day.
that that's the way the planning commission's set up. They have 5 regular members, and they have 1 member from the Board of Supervisors, and 1 member from the Board of Zoning Appeals, and what you just described is exactly how it's supposed to work. Only it doesn't, because they spend all their time, or not all their time, but a huge percentage of their time at every meeting going over these special use permits when they're having a public hearing, which I heard there was a memo and all this, and now last month they didn't have any public hearing, and they just recommended several of them for approval without any hearing at all, which they don't have to have, but whatever. They're supposed to determine if it's compatible with the comprehensive plan, period, and make a recommendation, if any, to us or to the Board of Supervisors. Instead of that, they have a mini hearing, they go through all the stuff, they have the people come and tell them all about it, and like they're gonna actually make a decision on it. And most of the time, they can't remember even to make in the motion, I move to recommend approval or disapproval. Instead, they say, I move to approve it, like they're the approving body. They're not. So then it gets to be 9 o'clock, as you well know, because you go to the meetings all the time. And last time it was what time? I don't know. I heard that midnight they went on till. So by that time, when you really need to focus on the thing and concentrate on, like, should it be this or should it be that or what's going to happen? I mean, when they get to that point of these ordinance amendments that really require some thought, they're all exhausted. And I'm not criticizing them, I'm just saying they need to either have work sessions or more meetings, and that's been brought up. And they say, yeah, they finally had 1. Great. And what came out of it? What did they decide to do after their July 11th workshop? Did they set it for public hearing yet? No.
did they have about 5 or 6 items that they wanted to progress forward?
They want it in strike-through version.
Well,
So
they've already had that. I mean, the strike-through version was given to them in March of 2016. That's how it started.
okay,
So let's not rehash all that. I'm just saying, the process that you're all describing is exactly how the planning commission is set up, and that's why it's set up that way, so that there's input from us through our representative, and from the Board of Supervisors through their representative, and that's how they're supposed to form a consensus and decide what to do. And it's not getting done, and it hasn't been getting done for a long, long time.
okay. Well, we can take
And there's
that.
not much we can do about it.
Now, do we want to do any other work session or?
Personally, I think it's a waste of time.
Yeah, it's not gonna make any difference.
Okay, well, let's,
I mean, if they're not interested
We'd
in,
be better off waiting and then reacting basically to what they come up with to see if they want to, you know,
Well,
You know how it affects us.
do we want to draft just a summary of the limited number of points that we brought forward?
I think that would be a very good idea.
Okay. so-
I agree, it would be a good idea if they would
And I
read
would,
it.
I
Well,
would
they
take
would
it
read
to the planning commission at the very next meeting.
I agree.
Okay.
I made copies, and I think I
I
gave
was
you,
hoping you'd read it. Yeah, I'll write something before the
I
next
can- you
time.
Could.
Yeah, I've got a copy. Yeah, I've got a copy.
it wasn't everything we talked about, but things that,
Okay, well, we'll do that.
all right.
And then the other item, just, and David alluded to it, but, you know, there was, the procedure of the planning commission is maybe still being worked out a little bit. But it wasn't several applications. For us, it was one application, but it was for a bed and breakfast. That was the initial, review, I guess. The intent was to make sure that the application was complete. But it wasn't, advertised and no neighbors notified.
Yes, the planning commission does not have to hold a public
Right.
hearing.
Okay, so my question about that was, so they just, and it was fairly late at the time, but they just took it, asked the applicant a couple of questions, and then moved to recommend approval. And so I was just curious if why that particular one would be recommended for approval. And there's no notice, so there would be no neighbor to know even that it was being brought up. And so here it would come to us with a recommendation for approval attached with no information other than what the applicant provided.
Well, I think to be fair about it, the planning commission was mostly concerned that the application was complete.
But they
and
recommended
accurate.
approval.
That they did because they recommended approval, and they also didn't have the second, as it is now, it's a double-barreled situation with the planning commission. They go for the first meeting to see that the application
But that's
is
what this one
complete.
was.
That's right. And then if the application is complete, you go to the second meeting, which is.
But they bypassed
They bypass that. And that's what, as I remember, Mr. Connick was encouraging to have this a one-meeting deal, just to.
But okay.
Right, but then
I agree.
after I recommended that, then they disagreed with it. They asked for a legal opinion. They got some 4 or 5 page harangue from Peter Luke saying, oh no, that's a perfectly okay thing. And Mr. Curry is the one who sat here, you were at our last meeting, told us
Okay.
about it, and now they deviated from that. So
But
I
my
don't understand what's going on.
The legal opinion said they had the right now opportunity to have a public hearing, did not say they had to have it.
But my question about it isn't so much whether or not they have a public hearing, it's of what value is a recommendation if they don't have any input from anybody.
So you're a body to make that determination
Well, that's
together
not
with
what
a public
I
hearing.
think.
That's where the planning commission is not about the neighbors. It's about the comprehensive
Yes, it's
plan
about
and
the
the
neighbors.
zoning
It's all
ordinance.
about the
The neighbors come to
This-
the board at the Board of Zoning Appeals.
Right.
But don't you think that there's the perception of some level of approval if the planning commission recommends approval for something?
Well, the planning commission is approving it in accordance
Recommending.
with the.
But this is the
with
first time
with
that's
the-
ever happened in my knowledge.
Okay, and
And
I
that's
think it's a
fine.
very
I'm
good
just-
precedent to set, that all they're approving is that the application is.
No, they're recommending, forwarding to us a recommendation that the application, the permit be granted.
Because the application is proper and it complies with the comprehensive plan and the zoning ordinance.
And
They-
I'm
and
saying-
that's all they're
Right,
saying.
and then when they come, when the application then comes here, this is where the neighbors should be told to come. And if they have objections
Okay.
or those kind of things.
Let's
for
put it on the
conditions.
other foot. What if an application comes to them, it's complete in every manner, and they want to recommend denial? They can do that too.
Sure.
And that'll
Of
come to
course,
us.
because-
with the
But that would be based on the plan, on the plan document, right?
I mean,
The comprehensive plan and the
So
zoning
it
ordinance.
doesn't meet the
No,
requirement.
let me ask the
It meets
members-
the requirements they're recommending denial.
Let me
They
ask
do that all
the
time.
members of this board, name me one, well, I could think of one, Harmony Manor. But other than that, I can't think of a single Board of Zoning Appeals decision that anybody, and even that one, where they based their decision on what the Planning Commission recommended. I certainly don't. I mean, I may agree with what the Planning Commission recommended, but I evaluate each one on its merits, and I hear what the people have to say, and sometimes I go to the Planning Commission, hear what they said there, and then I put all that together, and okay, that's very nice, they recommended for it, but I don't agree, and I don't think anybody else on the board
But I think that they
is bound by that.
I think they perceive themselves a little more important than that.
Well, maybe this will cut them down to
No, but I feel.
and maybe that'll be a good thing.
No, that was.
They're a
that's
planning
all I mean.
commission, they're not the boss of the Board of Zoning Appeals or the Board of Supervisors.
Okay, so they will never recommend an
I don't know, they can recommend whatever they want, and if, we'll look at it and say why they.
Because they usually table it for the individuals to get the application in order, or when they find out that they had to meet a standard that they were not aware of. So generally, they don't
Okay,
deny, they
okay.
generally ask them to bring back more information.
They tend to table, but.
And I said table.
All right, are we done with the
that's-
agenda? I move to adjourn because somebody's husband is having a
Okay.
birthday party.
Yeah, I guess we're done
Yeah, but-
Then I would like that we put on our next month's agenda. Oh no, that's gonna be the appeal.
Mm.
But that soon, we're gonna have to work on rules and time for a
I thought you added
review
that to
of,
the agenda.
huh?
I thought you added the rules and procedures to the agenda.
Yeah, we did.
We did, you're right.
Well, I thought it was for that rule, but
Okay,
we're
so
not
let's-
adopting it, so.
Okay, so let's just quickly do this. It sounded like in the discussion during the 15 Main Street that we didn't think it was such a great idea to adopt a new rules of procedure tonight. Is that correct? Because otherwise we would have
We've been
done it.
limping along without rules of,
We have rules of procedure.
we do, but they're, you can drive a Mack truck through them.
Okay, let's
So we-
get a copy of them and we'll discuss them at our next meeting. And we'll
Very good.
review them. No, it'll be the next meeting.
Because
It's a
what
regular
we
meeting.
have, some of
I
the
mean,
rules that
basically
we,
send out a copy in advance so everybody can look at it.
Rather than that, I mean, I don't know where those rules came from. I mean, I
Well,
sort of
Peter-
know who they came
Peter
from.
wrote them.
They came from the governor. So, what I recommend we do is, and if you want to take upon yourself to do it, it's very easy to go look at what Fauquier's BZA has and ask Mike Brown because he was on it. So they've got rules of procedure. Fairfax County Board of Zoning Appeals has rules of
Okay, so
procedure.
we'll get them.
And rather than try to reinvent the wheel, take those and compare to ours and see where
Is that
there's some
something you'll-
differences.
yeah, I can do that.
And pass those around, let everybody look at them and just let's throw the ones we've got out
And
and
for
then
reference-
substitute these.
But for reference, we can look at ours as well.
Yeah, also those two.
Just,
But I mean, two
uh,
things that, and I think one of them's already been done for sure as a result of what has arisen from here. And one thing is, the appeals form has to be amended. The appeals form, number one, has to tell them, if you are a legal entity, you've got to be represented by counsel. And instead of whatever it says on here, why you are aggrieved, I mean, you have to say state grounds of appeal.
Well, in our
And
appeals,
it says that.
in the appeals thing, it says the administrative, no, in the appeals, it says the administrative officer. So when it speaks of administrative officer, I've got the state code right there. Does that mean an attorney?
No, administrator
Because it says administrative officer.
of the LLC.
Oh, that would be of the,
Yeah, you're talking about.
At the appeals, it says that there will, the people that will be heard will be the administrative.
No, that's the zoning
She's the
administrator.
administrator.
Determination of the administrative officer shall be presumed to be correct, that's
That's
her.
her.
And shall explain the basis for his or her determination, after which the appellant has the burden of proof to rebut such presumption of correctness or preponderance of the evidence. And then the board considers, listens and considers. So the administrative officer then is her,
Right,
okay?
the zoning administrator.
But it truly doesn't say anything in here that it must be an attorney. who does that, but that maybe,
But that's not, it wouldn't be in the zoning ordinance if it's a legal
But-
entity like a
It
corporation.
depends on whether the
it's
applicant is an LLC.
15-2309, powers and duties of the Board of Zoning Appeals.
That has nothing to do with it. It has to do with the unauthorized practice of law, that if it's a legal entity,
We've been around.
Yeah,
you
we've already talked.
can't be represented except by counsel at a hearing.
Okay, so are we ready to adjourn?
I move to adjourn.
Is there a second?
Second.
All in favor?
Aye.
Thank you.
Sorry, Michelle. I told Michelle